All right, so we are now at 12 p.m. the official, oh, sorry, 11 a.m. I'm 1 hour ahead of you all. So we're going to get started now. So good morning, good afternoon, or good evening, everyone. My name is Melissa Loza. I work with the Consortium on Gender Security and Human Rights. And on behalf of myself and the consortium's director, Dr. Carol Cohn, it is my pleasure to welcome you to today's event on armed conflict, gender, and the rights of nature. Today's talk by Dr. Kina Yoshida is being run as a hybrid event with a live audience at UMass Boston, as well as participants from around the world joining us on Zoom. UMass Boston and its surrounding communities are based on the unceded homelands of the Massachusetts, Pawtucket, and Nipmuc people, and we want to honor the diverse Indigenous peoples' enduring relationships with their traditional territories and to acknowledge the ways land passed from Indigenous to non-Indigenous control is through a violent history of genocide and forced removal. The violent trauma of land being stolen from Indigenous people and the death, dispossession, and displacement of countless individuals and communities, all processes which remain ongoing today. We'd also like to emphasize that land acknowledgements by themselves are not enough. They are only one step in supporting Indigenous communities and need to be followed by action-building solidarity, by combating the ongoing structural and physical violence directed towards Indigenous peoples, and by supporting the Land Back movement. While people are still joining in, I'm going to take a few moments to give you some information about what to expect today. In terms of the structure of today's event, after Dr. Yoshida's talk, we will take questions from both in-person and Zoom audiences. For those of you on Zoom, we encourage you to put questions into the Q&A Q&A function, not chat function, at any time. Also, for people joining us on Zoom, the chat is on now, and we love to have any of you joining on Zoom remotely to introduce yourself in the chat function. The chat will be on for this introductory time and then again near the end if there are any resources or thoughts you would like to share in the chat. Also in the chat, you'll find information in a bit on how to access our closed captioning and who to contact if you're experiencing any technical difficulties. And when you leave the webinar, a very short survey will pop up, and we'd be very grateful if you could take a moment to fill it out, please. And now for everybody, we'd like you to know that this event is being recorded and the video will be available online on the consortium's website and on our YouTube channel. Finally, before I introduce our speaker, I'd like to thank Jessica Leonard, our closed captioner, and to express the consortium's gratitude to many UMass departments and programs that have generously co-sponsored this webinar, including the University of Massachusetts Boston's Office of the Provost, the Office of the Dean of Faculty, the Office for Faculty Development, the CLA Dean's Office, the School for Global Inclusion and Social Development, the Honors College, the Latino Studies Program, the Human Rights Minor, and the Departments of Conflict Resolution, Human Security, and Global Governance, History, Political Science, Sociology, and Women's Gender and Sexuality Studies. So with those acknowledgements, it is now my great pleasure and honor to introduce you to today's distinguished speaker, Dr. Kina Yoshida. Dr. Kina Yoshida is an international lawyer and a barrister in England, Wales, and Ireland. Dr. Yoshida is currently a legal advisor at the Center for Reproductive Rights, an associate tenant at Doty Street Chambers, and a visiting fellow at the Center for Women, Peace and Security at the London School of Economics and Political Science. Dr. Yoshida is co-editor of Feminist Conversations on Peace, Bristol University Press 2022, and co-author of How Many More Women, Exposing How the Law Silences Women, Allen and Unwin 2022, Octopus 2023. Dr. Yoshida has published work in international affairs, European Human Rights Law Review, Human Rights Quarterly, and sits on the board of a legal journal. Dr. Yoshida, thank you so much for being with us today, and I'm delighted to now turn it over to you. I believe you're still muted. Dr. Yoshida is just getting slides up. Should be good to go.
Great. Hello, everybody at home, and hello, everybody with me today. I hope everybody is well. It's a bit of a strange setup for me because I have these ear pods in, which means I can't really hear myself speak. But I hope you can all hear me talking. I want to give a big thank you to Carol Cohen, who has invited me here today, to all at UMass and to the Consortium on Gender Justice and Gender Security and Human Rights. Sorry. And I'm going to talk for about 45 minutes today on the protection of nature in conflict. And I'm going to do so from the perspective of international law and as an international lawyer. I don't know how many lawyers there are in the room. Do we have any lawyers? No? Okay, great. So if there's something that I say that you don't understand or is difficult or I've used some sort of legal jargon, please stop me, put up your hand, and I'm happy to explain it a bit further. In 2019, Lina Cespedes and I received a British Academy small grant to explore the intersections of gender, nature, and peace. The project sat under a broader project that I was working on with Christine Chinkin and Louise Arimatsu called Feminist Approaches to International Peace and Security. And we sought to bring together scholars from all different types of disciplines to look at the topic of international peace and security, environmental harms, degradation, and how gender fits in within the fragmented frameworks of international law. And that's one of the things I want to introduce to you today, a number of different subspecialisms and fragmented frameworks of international law, which regulate the environment in times of armed conflict, but which also might help us think about how we can gain accountability for those environmental harms in times of conflict. Here we go. And I just wanted to start with a picture from a workshop that we had in Colombia in 2019. This was before the pandemic. I chose this one because Carol's in it. And it was a really fantastic workshop that we had at the University of Rosario, bringing together different scholars from all different disciplines to look at this topic of what happens to the environment in times of conflict, and what does gender have to do with it? And does gender have anything to do with it? And the spoiler alert is that yes, it does.
Excuse me, Dr. Yoshida, I'm so sorry to interrupt, but for our Zoom viewers, it seems that you have to actually start the PowerPoint presentation itself, because currently your screen sharing, we only see the introductory slide, and we're not seeing that slide of your photo of the workshop. Could you click play from start, please, or play from current slide in the top left-hand corner of your screen?
I don't. It seems it's playing.
Let's see. We're just seeing. Okay, so that's the slide that that's the slide you've displayed to the live audience in person, and now we're seeing. You're probably just gonna have to click through the slides as you go through, if that's all right, so that our Zoom audience can see as well.
Can they still hear me?
Yes, at least I can.
Okay, well, I think while we're sorting the technology out, I should just continue just because of time. So we brought together these people and essentially we were looking at the different ways in which gender might come into play when we think of environmental degradation. Can you think here of a way that these two things might intersect? Gendered harms and environmental harms. I see some nods. Does anybody want to shout anything out? Well, I think one of the things that we found in the workshop was that a lot of people talked about climate migration, for example, and how this had gendered impacts and affecting women on the ground, affecting food scarcity, water scarcity, people having to move, even with micro movements because the land was no longer arable, and that this affected women in particular. Another thing that people said was that, well, it's not just that people need to move because of the effects of climate change, it's that once you had mega projects going in, women were not at the participating table in terms of negotiations because women in certain contexts can't own land. So that when people were called in to have environmental mediations or consultations on participation, women simply went there because the category of people that were called in were landowners. And nobody had thought to think, well, the law discriminates against women and therefore they're not going to be at the table, and how that would affect their right to participation. Another thing that our participants drew attention to was the impact on environmental rights defenders and women's rights defenders. So, for example, to use the Colombian conflict, because we were in the country Colombia for this workshop, people drew attention to how there was a peace accord in 2016, and yet environmental rights defenders and women's rights defenders continue to be attacked and continue to be killed. Therefore, asking the question, what does peace really mean if, for those working on the ground, they're still being targeted, killed, and criminalized? Another way in which the participants drew these links together, this slide is perfect, was with respect to the extractive industry. So people drew attention to the mining concessions, so the growing number of mining concessions that have been brought since the end of the armed conflict in Colombia, but how this turn has impacted the community where these mining mega projects have been taking place. There's been, come in if you'd like, there has been an increase in levels of sexual violence. There's been links to trafficking in human beings. And if you're interested in this topic, I would really recommend you having a look at the report of the Special Rapporteur on Trafficking. Wrote a report on the links between conflict and trafficking and looked specifically at the impact that extractive industries have.
Yeah.
Is that Melissa? We don't know.
Yes.
Sorry. How do we move to the next slide then? Now it's in play.
I just had to.
Okay.
There you go. Defending the future.
Great. Thank you. Fantastic. In 2020, together with Hannah Bond and Helen Kazea-Noha, we produced a report called Defending the Future. I wanted to see, and we wanted to see, if what we were hearing with the different participants in Colombia played out in similar 126 interviews with different stakeholders, including refugees and internally displaced people, mainly women, young women groups, women with disabilities, different intersecting factors, to see how climate change and conflict and environmental degradation were having an impact on their lives. And this report is available online, and I don't really want to talk too much about it here today, but I just want to flag that that's there for you to read if you're interested in the intersections of gender and the environment. But just to, so one looked at, again, this issue of food insecurity, water scarcity, which in turn linked to higher levels of gender-based violence. And this was one of the things we heard a lot of people say. Women in the households were responsible for ensuring there's food on the table, for ensuring there's water on the table. But the impacts of climate change meant that there was a lack of harvest, or that clean water, potable water, was more difficult to find. This in turn meant that their husbands or their partners became angry when those things weren't available, meaning that there were increases in levels of gender-based violence. So something like climate change that we might think of as over there, having real life impacts and immediate impacts on women and girls on the ground in different contexts. Right now, where I am in the research, and where this is, I really appreciate this opportunity to present, is asking a slightly different question. So it's continuing on from the work that Lena Cespedes and I have been doing where we were looking at things like the women, peace and security agenda, and then looking at the environmental peace building agenda and saying, well, the two agendas, they don't talk to each other. So women, peace and security is this UN Security Council framework, which started from 1325. I don't know how many of you are familiar with it, but it basically looks at women and war in a really, really simplistic way. The environmental peace building agenda is another type of literature and practice that has grown in parallel. But when Lena and I started looking into it, the two didn't really speak to each other. So we saw an absence of the environment in WPS, and we saw an absence of gender within environmental peace building. So that was what our earlier work was about. And now I've been interested in this question. Well, how can we think of the protection of the environment as agentic, as something we need to be accountable towards, including when it is harmed and damaged in conflict? And does a gender analysis have anything to do with this? So not simply looking at the environment as an object, but much more of a subject. And the answer to this question in international law is complicated because international law is fragmented between lots of different regimes of international law. So the first slide here relates to international humanitarian law. And this is something that I'm going to refer to as IHL. You might hear of it referred to as Jus in Bello as well. I don't know if that rings a bell. And you'll hear people talk about the Geneva Conventions and the Hague Conventions and Additional Protocol 1 and Additional Protocol 2 and all sorts of amendments. But for the purpose of today, what's important is that IHL has been amended in order to provide protections for the environment in armed conflict. But this is quite a recent story. And the story really started with the war in Vietnam. Until this point, even though the environment had been harmed in conflicts like the Second World War, the Geneva Conventions and the Hague Conventions didn't pay much attention to environmental harm as a part of the laws of IHL. Really recently, in the last 5 years, international lawyers are paying much more attention to this topic. And there are now 28 draft principles of the International Law Commission on the protection of the environment in relation to armed conflict. The International Law Commission is a specialist body which is tasked with progressively developing and updating international law. And for those of you who are interested in how the laws of war regulate and create accountability for environmental harms, I would really recommend you look at these 28 draft principles and the reports that go behind it. I mean, they're extensive and they're really fascinating. In addition to the laws of war, or IHL, one of the ways in which we might think about environmental destruction and harm during armed conflict is through the lens of international criminal law. The two are interrelated, but very briefly, the difference is the international criminal law is the law which essentially governs or regulates individual criminal responsibility for committing war crimes, crimes against humanity, genocide, and the crime of aggression. So, for example, the recent arrest warrant of Putin relates to international criminal law before the International Criminal Court, right? And that was established by something called the Rome Statute in 1998. I know this is a room of non-law students, so this is like really a whistle-top stop tour through international law. But basically, there's an article in the Rome Statute which makes it a crime to perpetrate environmental damage in the context of armed conflict. But no one's ever been prosecuted for this because the threshold is so high. So there's now a new proposal for a fifth crime to be added to the Rome Statute, and this is the crime of ecocide. And I was thinking, well, how how can I describe what the crime of ecocide is? But Philippe Sands, King's Counsel, who's an international lawyer, does this so well, and he's been looking at this and international environmental law for such a long time. And he says, if you leave this room and go and pour thousands of gallons of substance into a river in Oakland or Berkeley or San Francisco, you will be criminally prosecuted. No difference between that and you going out and someone up or killing someone. The criminal law is invoked. Exactly the same principle applies at the international level. You go off and destroy an ocean or a river or an entire species, or act in such a way as to create some massive transboundary eruption, which will deposit itself into the ocean and kill a species of fish or whatever. But there's no mechanism available today under international criminal law to address that. And ecocide is intended to fill that gap. So for some lawyers, they see that there is this gap or this part of a missing puzzle within international criminal law that people can go around committing essentially big scale environmental crimes, but international criminal law is not fit for purpose, or it doesn't criminalize that act. As if it wasn't complicated enough to have IHL and international criminal law, you have another area of international law, of which you probably might be more familiar, which is international human rights law. And international human rights law has had a very important greening story. So while the original and foundational treaties and conventions in international law were silent on the face of it with respect to environmental harms, they have been updated in the last years to recognize the importance of the right to a healthy environment. And now 2/3 of the constitutions in the world recognize this right. And in July 2022, so that's last year, really recently, the General Assembly recognized the standalone right to a healthy environment. So there's really lots and lots developing with respect to international law in this area. Why am I bringing up international human rights law at all? Well, one is international human rights law is a way to hold states accountable. It's not about individual criminal responsibility. It's not about international human rights law is still relevant and applicable in time in relation to human rights just don't go away. They're still applicable. I've been talking a lot on the international level, but it's also important to say that many of these examples also play out at the level of domestic law, national law, really important in the US, where you don't tend to have very strong international legal protections or rights. So you might have signed up to some treaties, but many of these treaties haven't been ratified by the US. I chose this example from one of the interviews that we did from the Defending the Future report. We spoke to a lawyer in Uganda, and she explained that the Constitution of Uganda provides that every Ugandan has a right to a clean and healthy environment. And they've been using that right to litigate all sorts of cases in the domestic courts against the use of single-use plastics. But my favorite case was about how they stopped the transport of chimpanzees from Uganda to zoos in China. And they did this on the basis that Ugandan citizens cannot enjoy a clean and healthy environment unless it had all its amenities to air, water, land, mineral resources, energy, and all plant and animal life together. So what we're seeing is an interesting, expansive, and creative use of international human rights law to try and protect not only human rights, but in some cases like this, also animal rights.
Dr. Yoshida?
Yes?
Would it all be possible for you to stand a little bit more in frame for our virtual audience where you are now?
Yes, I'll do my best.
Okay, thank you so much. Apologies.
But can you hear me, Melissa?
Perfectly, thank you.
Okay, perfect. Well, I think I will try and stand, but I'm also going to walk around as well, if that's okay.
Excellent.
Because it's quite dark standing.
Oh, yes, of course. Thank you.
Within human rights law, one of the really important areas in which environmental rights have developed has been in relation to Indigenous rights. And it has been Indigenous peoples who have been really pushing and at the forefront of trying to create an international human rights law that also includes environmental protection and also the protection that goes beyond simply a property or a right to property framework. And in these slides that I'm not going to delve into in any great detail, what I've done is I've just talked about a number of principles and cases that you can see in international law that have come from these this jurisprudence, which has mainly been decided by the Inter-American System of Human Rights. So I don't know how much people in this room will be familiar, but you have international human rights law and you have regional human rights systems as well. So you have the Inter-American Human Rights System, you'll have the African Human Rights System, you have the European Court of Human Rights as well, with the European Convention of Human Rights. And in Asia, you don't have a regional system of human rights, for example. And the Inter-American Court of Human Rights has been one of the most, has elaborated some of the environmental rights of all the different systems. And here we see principles like benefit sharing, consultation, or previous consultation, informed consent of Indigenous peoples, and also a recognition of a spiritual dimension in the relationship of land and territory with Indigenous peoples. This is all well and good, but there are some problems with the international law approaches that I have been talking about today. The first, in terms of trying to get of ecocide or international criminal law, is that it is one of international criminal responsibility. It's one in which accountability looks like an individual going to jail for environmental crimes. Okay, so very limited in its scope in terms of reparations. And you can ask yourself, well, how does the environment, what reparations are given to the environment in this circumstance? Another problem is you have all this great case law, you have all these great standards recognizing that Indigenous people's rights have been violated or that different human rights have been violated, but the damage has been done to the environment already. So you need principles like the precautionary principle in international environmental law to stop this damage. This picture is taken of a case I worked on. I was part of a group of lawyers where we submitted an amicus curiae brief, a third-party intervention in a court in Colombia, and it related to a case of the Bruno Arroyo in Colombia brought by the Wayuu peoples. And they said that the Cerrejón mining company had come in and it was deviating the river from its natural flow, thereby affecting the Wayuu people's rights to water, their rights to life, their right to subsistence. And the courts in Colombia agreed with them, the Constitutional Court, and said that this must stop and there has to be an environmental impact assessment and there had to be consultation and all these great principles that have been developed by the law. But we got asked to provide an amicus brief because the court's orders weren't implemented. And they wanted, the point here that I want to make is that even if you have good case law that does not turn into action on the ground always, and implementing international human rights standards is a major challenge. So getting your judgment is just the first step. Making it happen is quite another, and then can take other forms of litigation. This has led to a whole series of lawyers, especially from what's called third world approaches to international law, TWAIL, critiquing the international legal system and saying that, in fact, the whole structure of international law has been set up in a way to encourage or to facilitate environmental exploitation rather than to stop it. So I have some quotations there, but I have some other ones that I thought I'd read. So Usha Naratajan and Kishan Kode have argued that international environmental law and general international law are structured in ways that systematically reinforce ecological harm. Christine Chinkin and Mary Kaldor have said that scholarship in international law has demonstrated its complicity in silencing and reconstructing the subaltern, supporting assertions of title to colonize territories, and legalizing colonial exploitations of people and resources. And it's in part due to the structural bias of international law, its anthropocentric nature, that lawyers have called for a legal revolution. And I know it seems like it's taken us a long way to get there, but that is the background behind this movement for a recognition or a legal recognition of the rights of nature. The rights of nature is a different framework. It's not as developed as international human rights law or international criminal law, but it is a framework, particularly in domestic jurisdictions, which tries to reject this anthropocentric approach to the environment and to nature, which often looks at nature as a natural resource, to be extracted and a type of property, and instead guarantees rights to nature in different ways. So one might be through legal recognition and giving nature rights in and of itself. So to use an example, this means that nature, a river or a forest or the Amazon could be my client, just as other victims of abuse or survivors of abuse. So that in that way, nature has legal personhood. The other way that you have the rights of nature is constitutional guaranteed rights of nature, like you have in the constitutions of Ecuador and Bolivia. And they recognize a whole host of rights. And that's not just legal standing, but ideas of the right to exist, a right to regenerate, a right to thrive, a right to live in harmony with nature. It recognizes the rights of future generations and natural cycles of the environment. And the whole point of this is that it's trying to take those anthropocentric biases of the law and create a new legal vision, new legal systems in which the environment can speak for itself. And there's a really famous essay called Do Trees or Can Trees Have Standing by Professor Stone that you can read if you're interested in this topic. And it's really fascinating. So this rights of nature approach has particularly been recognized, as well as Ecuador and Bolivia, by the Colombian Constitutional Court. And to give an example, in the Atrato River case, the Constitutional Court of Colombia ordered the protections of the rights to life, health, water, food, and security, and a healthy environment, culture, and territory. And it also recognized the rights of the river itself and the need for guardianship to protect the river. In another case, the Supreme Court of Colombia declared that the Colombian Amazon is a subject of rights, and as such, the state is required to reduce deforestation. The importance of looking at the subject of rights, or the rights holder, isn't just about who has standing to bring a case, but it's also about remedies. In the end, that's what court cases quite often are all about, right? There's a certain type of harm, you want accountability, and you want reparations or a remedy for that harm. In law, the reparation or the remedy is quite often monetary. Someone comes along, they crash into your car. What do they need to do? They need to buy you a new car, or they need to give you money to buy a new car. In the case of the environment, however, it's not that easy. these remedies are much more difficult. And one of the, I think, really interesting questions that courts are grappling with now is this idea of, well, what do environmental reparations look like? What does it mean to make orders to regenerate the environment, or for the environment to thrive? What is that? It's not simply money. Money cannot restore the natural environment. It might help, but what is it that we can do? So the rights of nature approach rejects conceptions of nature as a commodity to be exploited for profit by people, and instead advocates for a new relationship with the earth. And this is a relationship that includes the need for a just balance among the economic, social, and environmental needs of present and future generations, and also is inclusive of the SDGs, for example, the Sustainable Development Goals. I want to turn now to an article that Lena and I wrote back in 2021 in International Affairs, where we decided to look at the Colombian conflict as a case study and looked at a particular case in which the Colombian jurisdiction for peace recognized the environment as a conflict in and of its, as a victim of the environment as a victim of the conflict in and of itself. I don't know if that sounds very novel to you in this room, but within international law, and particularly within international criminal law, that was a huge landmark decision for a court to make. And you can understand it, I think, when you understand that the Colombian Constitutional Court and the Colombian Supreme Court have been able to make these findings on the rights of nature previously in its jurisprudence. So it's not a case that just came out of absolutely nowhere. They had background and jurisprudence on which to build their answers. So this is the case. So it's called, in 2019, the Special Jurisdiction for Peace handed down a landmark decision in the case of the Catsasu concerning the Awa indigenous group in Colombia. The Colombian conflict has particularly affected indigenous groups and as such, the Awa people, and has also affected the territory in which they live. And the Colombian conflict resulted in the displacement of 6 million people, and the HEP has been set up to try crimes up until 2016, just to give a very brief overview. And it's a criminal jurisdiction that sits alongside a truth commission as well, that I'm going to talk briefly about. The special jurisdiction has found in that case that nature was a victim of the Colombian conflict. And it said that in particular, it acknowledged the indigenous peoples and their status as collective victims, and also looked particularly at the impacts on indigenous peoples who are associated with the defense of life of the territory, including the rivers, animals, the sea, the mangroves, the mountain, sacred sites, and persons. And the court noted how the conflict interrupts and attacks the spiritual, social, and independent harmony and knowledge of the land. And the quote here is in Spanish, and I've taken it directly from the decision itself. And I don't know if any of you speak Spanish in the room, but I think you get the profound sense of the court looking at the damage to the environment and the damage to the indigenous territories from the perspective of indigenous peoples, and not from the perspective of Western anthropocentric views. And it talks about how the violence affected the encantos, the protecting spirits, and the spiritual fathers, which transcend human ambits. And they say that it affected the rights of people, but also their relationships with places and non-human participants and agents. And that's a really important statement, and one of the rare ones that we see in this domestication of international criminal law ambit, like the HEP. The court also did this from a recognition of the different cosmologies that exist in the world. And they looked particularly, they said that they were going to take an intersectional perspective in looking at the issue, and looked at the place of Indigenous women and the harms to Indigenous women who are the carriers and custodians of ancestral knowledge. In addition to this, they found that the damage done to the territory and what happened in the Awa territory was a violation of women's rights, as well as the harms that were perpetrated on the environment. Following this, there has been another 2 different decisions which has recognized the territory as, or the environment as, a victim of the armed conflict in Colombia. And that's really significant. And I think this is significant for lots of different reasons. One is Eliana Cusato has written this absolutely brilliant book called The Ecologies of War and Peace that I really encourage you to read if you're interested in this topic. One of the things that Eliana talks about is that how, when nature is framed as a casualty or a victim of war crime, it's really difficult to prove the nexus, the doctrine of causation. So one of the things that you have to do in law is to prove that something caused something. And perhaps that is why it's been so difficult to get these recognitions within international law of the environment as a victim of conflicts. But we see here in these decisions an example of how courts have been able to do this, and they've been able to do this not only through environmental studies, but also through the testimonies of Indigenous people as well, and their knowledge about the land. This is a picture from a website from the link to the Colombian Truth Commission. Alongside the jurisdiction of peace, Colombia has been going through a truth and reconciliation process through a truth commission. And in July 2022, which was the same time that the General Assembly passed its resolution on their right to healthy and standalone healthy environment, the Truth Commission produced a 400-page report, final report on the Colombian armed conflict. And this report has a dedicated chapter on the environment as a victim of the conflict. I'm not sure I've read something that's been written in such a beautiful way in a very long time. The environmental chapter starts with these words. If they spoke the language of words, what would nature say about its experiences during the internal armed conflict in Colombia? Perhaps it would mention the fires which burned the trunks and the leaves of the trees, or the suffering of the thousands of animals, or the munitions which harmed the delicate ecosystems. But nature does not speak, but it does have other ways in which it communicates and tells stories. When it's healthy, it shows this through its vibrancy and its people, and humans can enjoy breathing the clean air. And the commission continues in this way, and that's my translation, paraphrasing what the commission is saying, in order to explain the many different harms that the environment suffered as a result of armed conflict. And I think this report is really worth reading. It makes the point that we deserve to live in harmony with nature, and that the environment should be protected during times of armed conflict. We see that spiritual link between the land and Indigenous communities, which it terms magical or mágicos ancestrales. And it came up with a term that I had not read before, and I found really interesting. which was, I'm trying to find it here, but I think it was sociocultural ecosystems. And it drew the link between humans, animals, plants, flora, fauna, land, and what happens underneath the land as well in terms of mining, to explain the different harms that happen to the environment. I think one of the most striking parts of the report as well is when it's looking at nature as a victim, is that the Commission explains that this can also be because nature is used as a weapon or is weaponized during armed conflict. So the use of caimans or the use of snakes to harm people is also a harm on nature itself. Or the throwing of dead bodies into a river is not only a violation of the rights to life of the human, but also of that river into which the bodies were thrown. So in the report, we see different accounts through testimonies of people of the spiritual harm and the ecological harm of the natural entities and how they were instrumentalized in war. And then you have a next chapter that goes on to explain the differences between nature and then natural resources, by which people often think of nature as something to be exploited. And it looks in particular at two things that I want to end with because I see the time. And the first is illegal mining, and it looks at the impact of illegal mining on the environment. And the second one is the use of aerial spraying of glyphosate. I'm so used to saying this in Spanish that I often mispronounce it in English, which occurred during the armed conflict in Colombia. And here I want to bring it back to where I started with looking at, well, what are the links between conflict, environmental degradation, and gender? This is a project by my colleagues in the Center for Reproductive Rights in the Latin American and Caribbean team. They have been looking at the impact of the glyphosate spraying, aerial spraying during the armed conflict of Colombia on sexual and reproductive rights. This was a process during the Colombian conflict. I'm not sure how many people know about this, but whereby the government or state forces essentially would use this toxic spray they would use the airplanes to spray the toxins on land in which they believed that coca leaves were being cultivated. And they did this because they believed that coca leaves were being used and being turned into cocaine and then being used to fuel the war. But this spraying had impacts, as the Truth Commission notes, on the environment. But as my colleagues in the Center for Reproductive Rights have been working on, it also had impacts on women's reproductive health as well, including resulting in miscarriages. And in the case of one woman whose case is currently pending before the Inter-American System of Human Rights that we were talking about, she died. And it's really, the report is on the Center for Reproductive Rights website. It's really worth reading. I think it's a very good example of taking these three different structures and putting them together. The structural violence of environmental degradation, of conflict, and then gender inequality to show the real life consequences that people face when this happens. The other example that I just want to end with as well is the extractivist economy. And this is because it came up again and again in the two workshops that Lena and I organized. But there's also a really brilliant report by the Special Rapporteur on contemporary forms of racism on colonial extractivist legacies, and linking this to different forms and structures of subordination, including gender inequality. And she says that, unsurprisingly, the extractivist economy has gendered effects, imposing and interacting with patriarchal power arrangements that marginalize an oppression of the human rights. The presence of an extractive site can present a danger to the enjoyment of human rights by Indigenous, Afro-descendant, and other historically, racially, ethnically discriminated against women, by increasing the likelihood of violence and decreasing governmental protection. And the last quotation isn't from her report, but it's from the report of the Special Rapporteur on Trafficking that I was talking about earlier. So we're seeing, I think, a much greater awareness at the international human rights level on the links between these structural forms of oppression that Bell Hooks talked about in terms of extractivist, colonial, patriarchal structures, and then looking at international rights, human rights responses to these. And another place you can see that as well is through the work of the Committee on the Elimination of All Forms of Discrimination Against Women, through their general recommendation number 35, which looks at violence against women. And really, this is just to say, one of the big missing pieces in the puzzle in international law is how it always focuses on the states and the accountability of state power. But what these reports, and I think more recent academic work is doing, and also in our interviews with the Women in Defending the Future and the experts, is the complicity and the responsibility and the accountability of corporate actors and corporate powers in all of this. And in terms of ecological degradation, how it is that the different legal instruments can be used to hold corporate actors to account as well for these violations. I think I'm going to stop it here and then take any questions that we might have.
And Dr. Yoshida, just in case, for our virtual participants, could you make sure to say questions from in-person attendees aloud?
Yes, of course.
Thank you so much.
Does anybody have any questions? Yes.
I think we were really not getting student in the program here. My question is, under the provisions of international law, whether that's existing articles of the Rome Statute that you mentioned, or the proposed one on Ecocide, is intent required to determine criminal culpability or negligence of the site, as long as there's that possibility?
Okay, so for the people at home, the question was about the elements of the crime required under the mens rea, essentially, element of the war crime in the Rome Statute in relation to environmental damage. And this is for a widespread, severe and long-term damage to be caused on the environment. My understanding is that there would have to be, that there is a mens rea element to this, but I'd need to go back and look at the exact wording of the statute in relation to that. And I think the difficulty of proving the different elements, especially this idea of long-term severe and widespread damage, has been a part of the reason why this group of experts in 2021 has asked for a new fifth crime to be added to the statute of ecocide, which would be easier to prove. And Eliana Cassato says in her book that, basically it's just extremely difficult to prove those elements in the war crime as it is. And I think a part of this is because of the way that ecological damage happens. It's not, a war is going on or a conflict is going on, and you'll have the prosecutors will put out an indictment. But it might not be evident at that time when the war is going on or when evidence is being gathered, the environmental damage that has been caused to the conflict. That damage may only be seen to happen decades after a crime has been happening, or it might not be so visible, or it might be very difficult to collect evidence of environmental damage. And we're seeing that at the moment with the war in Ukraine, that there's lots of different initiatives to collect evidence of environmental damage by different groups as it's ongoing. But I think it can be particularly difficult for issues of causation in international criminal law. Sorry? So the question was around the statute of limitations for environmental crimes and harms. That's a really great question. It's always a lawyer's question. But I think that would be dependent on the different systems. One of the interesting things with international human rights law is that you have this concept of ongoing violations, right? So instead of saying, okay, something has stopped, you can argue that the violation is ongoing because the ecological harm is ongoing, for example. Do you have a question? Yes. Can you speak slightly louder? Sorry.
So I just want you to talk about the environment, but what in terms of like the environment, like corporations like Shein, right? Like that, but like they produce a ton of products and then goes to it. These are like polyester, plastics, and affecting the environment in a negative way. Which like goes affecting plastics. People have really deposit, but it's like a foreseeable consequence.
So I think the question was about corporate actors who, as a foreseeable consequence of their actions, cause ecological harms such as pollutants, toxins, all of that. I think that is where a lot of the environmental groups are going, you know, or where they are. They're trying to get a treaty in place to create responsibility of corporate actors. I don't see, you know, there's people like Gretchen Bars, who's an international legal scholar, who's working on the responsibility of corporations. There is, in addition to all these different frameworks of international law I've been talking about today, there is this other subspecialism of international law called international environmental law. And it is its own specialism, which has its own rules, and it has many different treaties with respect to obligations on conservation. You have treaties against transboundary pollution. You have due diligence principles or positive obligations, as we call them under the European system, not to have pollution. In the UK, for example, we've had one of the first inquests. That's when somebody dies and there's a state investigation looking into air pollution as a contributory cause, for example, of someone's death. And, you know, the right to a standalone healthy environment is so important because people say the right to clean air forms part of that. So I think it's a great question, and one that environmental groups are pushing and that we all need to be looking at.
We also have a few questions in the Zoom Q&A if there are no in-person questions as well.
Sorry, there are or there aren't?
There are about 5 questions in the Zoom Q&A.
I can't see them. Ah, yes. Okay. Thank you.
Yes.
Yeah. So first question is, yesterday the General Assembly adopted a resolution to ask the International Court of Justice for its advisory opinion on climate change. Do you think this could deliver a legal basis for climate justice? I think I want to congratulate the government of Vanuatu on this. The General Assembly adopted the resolution by way of consensus. The co-author of one of my books was in the legal team, so obviously I'm really happy for her and the work that the legal teams have been doing. And yeah, I think it's really exciting that the International Court of Justice is being asked this question. And I think it is an opportunity for the ICJ to substantively answer the question on environmental rights and climate justice, where it has failed to do so in the past. And I say this from the point of view of nuclear weapons and nuclear testing. So I don't know how long I've got, but this is one of my pet issues, but the International Court of Justice has been called upon to answer. And so the ICJ, International Court of Justice, is different to the International Criminal Court. It does not prosecute people and hear trials of individuals for international criminal responsibility. Instead, it is a world court, and it's a body usually which is called upon to adjudicate on state-state disputes. So that's it. It's based in The Hague. The other function that it has is that it can be asked for advisory opinions on certain subjects of international law. It's being asked now, as this question talks about, to give an advisory opinion on climate change. It has previously been asked to give advisory opinions on the topic of nuclear weapons. And that judgment is extremely disappointing with respect to environmental rights. There was a more recent case, the Marshall Islands case, in which some island territories also asked the international ICJ to adjudicate on the use of nuclear weapons. And the court used jurisdictional arguments and it declined essentially to give substantive reasoning in that case. So I think it's really historic, and I think it's something that we can be really hopeful for. And I think it's an opportunity for the court to move us towards climate justice. There are so much rights and conventions available. How can we get the territories to be made accountable? Yes, I mean, that is the question. Christina Voigt has an absolutely brilliant quotation that I love to use. She's a professor of environmental law, and she talks about, with the sheer number of conventions and the sheer number of laws and the different things that we have in international law, why is it that none of this has stopped environmental degradation that we have? And that is where the Twale scholars argue then that it's because the international legal system is complicit in the ecological harm, and why then some scholars argue that you need a rights of nature framework or a non-anthropocentric or even post-human feminist framework, so that's Emily Jones, to put a halt to the ecological harm and to have greater accountability. I think the environmental damage of nuclear weapons production question, I mean, my only answer to that is that you could also check general comment number 36, updating on the right to life of the Human Rights Committee, which also looks at the impact of nuclear weapons on the right to life, and also looks at the environmental impact of that. Do you want me to keep going?
So that's another 10 minutes.
Okay, great. Let me have a look. So we have a question by Carlos Perez Esfitia. As you have mentioned, establishing nature and the environment as a subject of the special protection by the Constitutional Court in the cases of Colombia has moved the agenda towards new challenges that should have been realized, but they are still very complex to measure. I believe a similar approach occurs within the jurisprudence of the Inter-American System of Human Rights and the rights of Indigenous peoples and their conservation, with its connections to the environment. Still, it is not enough, even though the advances in legal terms are impressive. What do you think is the most significant challenge international domestic law faces for effectively implementing the normative frameworks adopted? And what is the priority on the agenda to achieve the effective performance? I don't know about the most significant challenge, but perhaps what I will end with is that there's something completely wrong in a system whereby, and I'm not talking about Colombia only, but in other jurisdictions as well, in where you have such normative development and good standards being produced, and yet the very people who are trying to advocate for those rights, the environmental human rights defenders, are being killed. And I see this as an absolute major challenge, because if you have people who are bringing cases and who are defending these cases in court, but at the same time trying to implement these decisions, but are being attacked for doing so, then your rights of nature standards, you have to really question what they mean. And this goes back then to this idea of, well, what sustainable peace really means as well. Because if you have this idea of conflict versus peace, and you have a peace accord that's been signed, but the people who are trying to fight for an environmental peace are the ones that are still being targeted, or are being targeted at higher rates, and you have, say, paramilitary complicity within that, or ex-paramilitary being hired to, for example, in some of our research participants were talking about in conservation zones, ex-paramilitaries were being hired and then using violence against Indigenous peoples. You have to really query the whole concept of what peace actually is. So I guess my big plea in accountability, I think it's really important that we move towards embracing the environment as a subject and not just an object, of being creative around what environmental reparations look like. And that's also, there's really interesting work as well now in climate reparations as well, but also defending and strengthening the defense of environmental and human rights defenders. And that is not just against killings and you know, the more extreme attacks, but also against the use of civil suits against human rights defenders, SLAP actions, so the strategic lawsuits against public participation. We need the whole legal system, I think, to be analysed to show, you know, corporate actors just have so much power. They can use so much with their money and legal tools and legal power to silence environmental rights activists and those trying to get accountability. So I think I'm going to end there, Carol, if that's okay.
Thank you so much. I'm just going to get our closing slide up. Here we go. All right. So thank you so much, Dr. Yoshida. Everybody, both our virtual audience and our in-person audience, please join me and the consortium in thanking Dr. Yoshida for this incredible, fascinating, wonderful talk. If you joined us on Zoom, we would be very appreciative if you filled out the minute survey that should pop up on your screen once you've left. And we hope to all see you again at future consortium events. And again, you can follow Dr. Yoshida and her work on the Twitter available here, the hashtags, as well as the consortium's Twitter. Thank you again, Dr. Yoshida. This was excellent. Thank you so much.
Thank you. Thank you, everyone. Thank you.